rise.
Yes, Mr. Ostrowski.
My lords, you should have in front of you a single sheet of paper, which is the entitled Interested Parties Submissions on Consequential Matters.
Yeah.
That contains at paragraph 4 the grounds of appeal submitted to the
Right, so that is.
And to that, in fairness, in identical terms to the paragraph in the notice of appeal, but it's always wise to check.
Yeah, yes,
That is, as it were, the authentic ground of appeal.
indeed. Yeah, and my learned friend very kindly printed copies of it, so please do thank you.
Thank you, Mr. Wright. Thank you both very much for that. Good. Let's put that somewhere safe.
I put it in front of 79, which is the order. After 79.
After 79. Yes, we're putting it, we'll call it 79A. Better name for it. Good. Yes, Mr. Malik.
My lords, you have my skeleton argument. My lords have also seen the upper tribunal's detailed judgment. So instead of simply repeating what has already been said in writing, what I propose to do this afternoon is to seek to assist you in relation to certain submissions that my learned friend made orally this morning.
Yes.
And subject to any observations, I will take the point in the order in which my learned friend has advanced them.
So what you're doing now is, you're about to do that, but you're adopting as your argument that which is in your skeleton argument.
Yes.
Without taking us to any particular passages of it.
No.
Understood. And now you're going to address the points raised in opening by Mr. Ostrowski.
Yes.
Yes.
So my lords will recall that my learned friend took you to 7 authorities before making a submission that it was arguable that the underlying appeal to the first-tier tribunal was doomed to fail. Well, I submit with the greatest of respect and diffidence that none of those authorities, save as to the last one, provides any real assistance to this court in this case, and they certainly provide no assistance to the Secretary of State. What is immediately obvious is that in none of those cases, the courts considered the issue that is before the court today, namely, when is it that the time to bring an appeal starts to run? So if I had challenged the Secretary of State's decision of 30th of November 2016 by way of judicial review.
Do you mean the decision or do you mean the notice of decision?
Either the decision or the notice, on the basis and on the ground that the decision was unlawful, the decision or notice was unlawful or invalid because of the failure to comply with the notice's regulations, those authorities might have provided some assistance. But I'm not challenging that decision or that order, and I'm certainly not challenging that decision or that order on the basis of a technicality. I accept that the Secretary of State refused the respondent's EEA application on 30th of November 2016. And I also accept that that was a valid refusal of his application. But I disagree with that decision on merits. I seek to appeal it and to argue that I seek to appeal to the first-tier tribunal to argue that the decision is wrong in fact. So the real question in my respective submission is not whether that decision or that notice is completely void or had no effect whatsoever. The question is whether, for the purpose of Rule 19 of the first-tier tribunal procedure rules, the time to bring an appeal started to run from the date of that decision. So in my submission, the court should approach the authorities, the 7 authorities that Milan and Trent has taken you to, with caution and with that in mind. So may I then just very briefly address the court as to the 7 authorities. My lords will recall that the first authority that Milan and Trent took you to was behind tab 11 of the authorities bundle, the judgment in Jayanathan. There is no dispute as to what this judgment says. And the propositions that Milan and Trent sought to advance. Can I just highlight 2, or in fact 3 passages, 3 sentences from the judgment? First, if you look at page 59 of the bundle, just look against letter G. The important question, and that would be, in my respective submission, a question in a case of that sort where there is a challenge directly to the validity of the notice, is what legislator should be judged to have intended. Should be the consequence of non-compliance. May I then respectfully ask you to look at, I mean, of course, this is the paragraph that my Lord Justice Lewis highlighted when Milan and Friend was making his submissions, page 61, right at the end against letter H. The requirement relating to notification of the appellant's right of appeal was mandatory.
This is actually quoting Lord Hailsham, isn't
Yes.
it? Yeah.
Absolutely. And then the 3 questions at page 63. There is absolutely no doubt in my respectful submission that the answer to question 1, if it arises at all in this context, is no. There wasn't substantial compliance with the requirement of the notices regulations. The non-compliance, this is question 2, was capable of being waived. The respondent has waived that non-compliance insofar as the respondent has filed a notice of appeal with the first-tier tribunal. The third question does not really, in my respectful submission, arise in this case. But if it arises, the consequence, in my respective submission, is that the time to bring an appeal starts to run from the date on which a compliant notice is issued.
Did you say a compliant notice, i.e. all the requirements of Regulation 5 must be met, because some of them are different?
Yeah.
Or do you accept a substantial compliance?
Well, I mean, of course, well, for the purpose of this appeal, I have no difficulty in agreeing with Milan and Friend insofar as he submits that there are different requirements under the notices regulations, and it may be that a different approach to different requirements is justified.
You might say that in the case of a failure to comply with the requirement to give notice of an appeal, if you read some of what Lord Hersham says, you never get to substantial compliance. That of itself means
Yes, of course.
it's not a compliant notice and can't trigger the notice of appeal.
At
But there
all,
may be
yes.
other provisions, such as the section or whatever, where you could have different arguments. So although I appreciate you could say at the very least,
Yes.
this can't be substantial compliance,
Yeah.
it might be helpful if you've got any submissions about whether non-information or misinformation, as in this case, reappeal is always results in the notice being invalid, or put differently, always results in the time when you're being triggered, when you're told about the notice of appeal.
If the information about the right of appeal is missing, that is the fundamental requirement, then in my submission, there will always be substantial non-compliance.
In a sense, it doesn't matter whether you call it mandatory or
No,
substantial non-compliance.
no. That is absolutely fundamental when one looks at the notices regulations.
What if it was given by hand and the official said, don't worry about what the notice says, they always put that in, but it's wrong, you do have a right to appeal.
Well, that would still be, in my respective submission, substantial non-compliance.
Because
Given-
the notice doesn't say it.
Notice in writing, that is the requirement not only under the notices regulations, but under primary legislation. This is section 4 of the Immigration Act 1971, which says that the power to grant leave or refuse leave is to be exercised by notice in writing to the person concerned.
Yeah, but this is EEA, and it's really Regulation 4.1, a written notice.
Written notice, precisely.
That's not an EEA decision, but you say it doesn't really matter that it's either always substantial non-compliance or it's mandatory.
Yes.
Yes.
So no real dispute as to what this authority says, but if one applies the authority, the answer in my respective submission is that the Secretary of State's case is simply untenable. The next authority that Miller and Friend took you to was the decision in the case of Shahid. Well, this is the supplementary authorities that were provided. In my respective submission, all one needs to do is to look at paragraph 20 to know that that case is of no assistance whatsoever. Last two sentences of paragraph 20, page 505 of the bundle. Lord Reed said that the authorities, such as Suniji, were fundamentally different. So that case, absolutely no doubt, is fundamentally different. It says absolutely nothing as to what should happen in relation to the sort of authorities referred at the end of paragraph 20.
But at the beginning of paragraph 20 also, the problem there was that the purpose of interpretation, which was being urged upon the court, flew in the face of the express language of the legislation, which did say what should be the consequence.
Yes. This is a case where there is no such express language in the legislation, as is recognized in the later part of paragraph 20. So the judgment, therefore, provides no assistance in my respectful submission, no assistance whatsoever in relation to the question that is before the court.
I mean, this is not a question of interpretation.
Not the question of interpretation of
Well, it may be a question of interpretation, but it's not one where the rules expressly say what the answer
not
is.
No,
that-
no.
It may be that what we're interpreting is 19.2b.
Yes, what is?
And it may be that these Jane Athan cases are not relevant in the way that if you're saying this action is invalid because you didn't do something, but it may be relevant in helping to understand what Parliament intended when it approved 19.2b. But on one analysis, this case is exactly about a question of statutory interpretation.
Yes, in interpretation of Rule 19.2 in particular.
Yeah.
Millennium Trent then took you to the North Somerset case, 23, and I entirely accept that judgment accurately summarizes earlier authorities on the subject.
Which passage have you got in mind?
Or if you look at page 193 of the bundle, paragraph, look at paragraph 43. The only point that I wanted to highlight is one that Millennium Trent, in answer to a question from the bench, accepted. In relation to what is said in the third line, there being the first question, did the Parliament intend total invalidity? And when Millennium Trent was making his submissions, he submitted that the answer to that question was no. Well, intended is not equivalent to expressly stated, and that authority in my submission tells us nothing as to what Parliament intended by the notices, regulations, and Rule 19.2 of the procedure rules. Millennium Trent then took the court to Majid, tab 21. That was a challenge to the underlying decision. And Millennium Trent ultimately accepted that there was nothing in that authority that provided any assistance to the court. He said that he would not rely on that authority. The next authority was Huang, tab 25. Again, Lord will see it provides no assistance. That was a case where the Secretary of State had certified a case under Section 94, but referred to the wrong subsection. The question was whether that had invalidated the notice. It did not. But that is not this case. But it may assist to look at paragraph 58 of the judgment, page 251. And if you look at the second sentence of that paragraph, it is inconceivable that the claimant could, by this defective documentation, have been misled into believing that she had a sustainable in-country right of appeal. And of course, if the only thing that is wrong is the citation of subsection, it's different. But surely this is a case where the defective notice was capable of misleading the reader into believing that there is no right of appeal. It was plain from that decision that the human rights claim was being certified as clearly unfounded. It was equally plain, in my respectful submission, from the decision in this case, that the Secretary of State was saying that there wasn't a right of appeal. The advice that she now accepts was wrong.
When you say it was capable, capable of misleading, I mean, it was on its face misleading.
Absolutely.
Is that not right? Don't think there's a dispute about that.
No, I mean, I was seeking to put the point as mildly as possible, but
Yes,
there is absolutely no doubt that the
mean, one-
statement was misleading. It actually misled the respondent in believing that he had no right of appeal.
One could perhaps postulate particular language that might have been capable of misleading about the availability of an appeal. But where you say you do not have an appeal,
Yes,
that is misleading.
it is.
We're not into the question here, I think, as to whether in fact somebody was misled.
No.
Whether it was the appellant or his advisors. That's not the realm of this appeal, as I understand it.
No.
The point is that the language on the face of the notice was misleading
Yes,
because it was diametrically the opposite of what actually the law was, as subsequently was made clear by the Court of Appeal.
yes, yes.
The thing that troubles me on merits is this really. I understand that before Khan, everyone thought wrongly that there was no right of appeal. And I don't have, and we don't have any evidence of what your client thought up until Khan. We do know he was bringing judicial reviews in relation to later decisions
Yes.
against decisions, and indeed those went all the way up to the Court of Appeal, and he sought permission from the Court of Appeal. Now, I suppose you'll tell me it's not a question I should speculate about, but what if he'd mentioned that one of the things that had happened to him was that he'd applied for a residence card and he'd turned down, and the sister said, well, why didn't you challenge it? And he said, oh no, I was told I couldn't. And the sister said in 2019 or 2020, oh, well, that was wrong, of course you can appeal. And he just decided to wait and wait and wait. You would say none of my business, would you? Well, you put it politely, but...
Yes, that isn't a question that arises. I have an answer to that if my lord wants me to answer it.
Interested to know what the answer is.
It was only in 2022, shortly before filing the notice of appeal, when the respondent became aware for the first time that he was eligible to bring an appeal against the EA decision that was taken in 2016. He was previously represented by different solicitors at different times. Solicitor who sits behind me saw the respondent for the first time shortly before filing of the notice of appeal, and the notice of appeal was then filed. And I have made a point in my skeleton argument as to the purpose of the notices, regulations, and why Parliament felt it appropriate to place an obligation on the Secretary of State to provide a prescriptive and detailed advice about the appeal rights in notices. In this jurisdiction, people who are in the respondent's position often have little knowledge of English and less of law. The law is so complex, adopting what this court has said in another judgment, that even expert lawyers are finding it impossible to understand the rights. And you then have a situation where the Secretary of State advises a person very clearly that you do not have a right of appeal. It is not unreasonable for that person to then proceed on the basis that there isn't a right. So the answer to your question, my lord, is that this is what had happened. It was only in 2022 when he was
So on
told.
the facts, it was only 2022. But in any event, you would say to me, I'm sure that,
Yeah.
well, the Secretary of State created the problem. She told people that there was no right of appeal.
Absolutely.
If when it became clear that was wrong, and if she wanted to block a loophole of people thinking, well, I'm all right now, I haven't had a notice, then she could have sent corrected notices out, and we would turn on instructions, I'm sure. But she didn't have that practice, so that's her problem,
Yes.
not the problem of people in your client or similar position.
Absolutely. And this is one of the points that I've made in my skeleton argument, that the remedy, if any problem arises, was always in the Secretary of State's hands. She was required to comply with the law. If she failed to comply with the law, then it was for her to rectify the position.
Yeah.
Miller and Friend then took you to CM Jamaica and relied heavily on that authority. But again, a simple reading of the facts will tell you that it was a very, very different case. tab 24 of the bundle if you wish to look at it again. That again wasn't a challenge to the decision refusing to extend time or holding that the appeal was out of time. Unlike this case, that appellant was advised that there was a right of appeal. But he was advised that the appeal could only be pursued from abroad. So the case, in my respectful submission, is fundamentally different. But may I respectfully ask you to look at paragraph 28 of the judgment to see what the Home Secretary was arguing in that case. It's page 237 of the bundle. So when the appellant sought to challenge the underlying deportation decision, namely, and he sought to argue that, well, he should be able to return to the UK to bring an appeal, the Secretary of State argued that the appellant could have pursued an appeal under Section 82 if he wanted to, but as a matter of fact, he has never commenced an appeal either in the United Kingdom or from outside the United Kingdom. Well, this respondent is, of course, in a fundamentally different position. Well, he did precisely what the Secretary of State said in that case the appellant did not do. He brought an appeal. And what the court held essentially was that, well, given that he had already left the country, there was no point to unscramble things for him to be able to come back to pursue an in-country appeal, because he could conveniently pursue the appeal from outside the UK. This is paragraphs 32 to 37. In a very different case.
Some paragraphs.
Paragraphs 32 to 37, where it was essentially said that, well, there's no point to unscramble things because he could conveniently pursue the appeal outside the UK.
Oh, yes, yes.
But one of the reasons why the court said that, well, it wasn't really appropriate to unscramble things is set out at paragraph 32. The Secretary of State said very fairly in that case that, well, if the respondent was to bring an appeal, she would not oppose an extension of time application.
Which would create the same time window for an appeal as would apply if the appeal were pursued in country. Out of country,
Yes. No such concession is made by the Secretary of State in this case, and that is the reason why we are before this court. I mean, the respondent, of course, has no desire to make any technical legal arguments.
No.
If the Secretary of State had made a concession of that sort, that would have addressed the problem.
No.
I'll have to read this again, but I get the impression that this was all about the validity of the deportation.
Absolutely,
Oh,
the underlying decision, yes. The underlying
all of this
decision.
was by the by,
Yes.
as to whether it would be conceded and so on.
Yes.
And they could have agreed, well, it might have been difficult for them to agree that the tribunal had jurisdiction because it was within time, because parties can't confer jurisdiction, and if there's an issue, but they can agree to solve problems by saying we won't object to things being brought out of time.
Yes, I mean, so the parties, of course, cannot agree to give jurisdiction to the tribunal that it does not have. But the courts have said that the question as to the extension of time does not really go to the jurisdiction of the court. It's a question as to the adjudicative jurisdiction, as it is called, rather than the constitutive jurisdiction. But no such concession is made by the Secretary of State in this instance. But nothing in CM Jamaica assists. And the final and seventh authority that Millennium Trent took you to was OS Russia, a different case again, because that was a challenge to the underlying notice or decision. But if my lords wish to see what Parliament had intended when it enacted the notices regulations, then that is at paragraph 41, page 288, last sentence. I consider, said Lord Mr. Sullivan, Parliament would have intended that a failure in a notice of decision to comply with the requirements to advise a claimant that he was entitled to an in-country right of appeal would render the notice invalid. I emphasize notice as opposed to refusal of leave to remain. And then if there is a challenge by way of judicial review, paragraph 42 tells us the approach that the court would adopt. If, for example, the claimant was made aware of other correspondence from the respondent that there was a right of appeal, or where the first-tier tribunal had accepted jurisdiction, then the normal response would be to refuse the application for judicial review. But otherwise, the judicial review claim will succeed and the decision would be quashed. Again, not this case, because I'm not seeking to challenge that notice on any technicality. So, but what is remarkable in my respectful submission is that Miller & Trent does not submit that there was substantial compliance with the notices regulations. He is right not to make that argument, and that is telling. He makes an alternative argument. He says that it is arguable that the appeal to the first-tier tribunal is doomed to fail. My lords have taken a note of the submission that Miller & Trent has made. He is not saying that the appeal is doomed to fail. He's not making that submission.
Right.
He's saying that it is merely arguable that the appeal is doomed to fail. That's what he said in his skeleton argument too. He says that the first-tier tribunal could adopt a procedure akin to summary judgment and decide in cases of this sort whether an appeal is doomed to fail. Well, this, with respect, is simply unheard of in this jurisdiction. It is not allowed by the primary legislation or the rules, or indeed by the practice direction issued by my lord, the senior president, or the practice statement issued by the Chamber's president. You'll have to rewrite the legislation, the rules, the practice direction, and the practice statement to introduce this extraordinary step. Now, Parliament has legislated to exclude hopeless appeals. The court knows that that is done by Section 94 of the 2002 Act. If the Secretary of State takes the view that an appeal is clearly unfounded, it is hopeless, it is bound to fail, the Secretary of State will certify the case under Section 94. If there is a certificate, there can be no in-country appeal. If there is no certificate and there is an appeal, it has to be determined on merits following a fact-finding hearing. To answer a question that my Lord Justice Lewis made, there is no power to strike out a case on the basis that it's hopeless or it has no real prospect of success, as is the case in the CPR.
And here you haven't even got section 94 though. I mean, this isn't an application for leave, this is an application for a residence card.
Yes.
There's still nothing in the regulations, the 2006 regulations as was, to deal with that. It simply says there's an appeal.
Yes. But in my respect submission, the rather fundamental point is that the tribunal has no power to decline to adjudicate an appeal on the basis that it's hopeless. The tribunal is obliged, and this is an obligation under the statute, to decide the appeal on merits and to determine the grounds of appeal. Now, under the rules, and this is another reason why the proposition that Miller and Friends seeks to advance is simply unworkable. Well, under the rules, the procedure rules, all an appellant is required to do in order to bring an appeal is to set out his grounds of appeal. Nothing more than that so far as relevant. If you wish to look at the rules, tab 7 of the authorities bundle, and the relevant rule is rule 19, page 42 of the bundle, sub-rule 4. The notice of appeal must set out the grounds of appeal. It's page 42 of the bundle. Now, the grounds of appeal are identified in the legislation, in the primary legislation and in the regulations. The way in which the system works, and this is based on the practice direction issued by my Lord the Senior President, is that an appellant files a notice of appeal on the online portal, my HMCTS, with the grounds of appeal, nothing else. He is not required to provide any evidence at that stage. In fact, he is not allowed, they are not even allowed to submit any evidence at that stage. Once the notice of appeal is submitted, then my Lord's, the Senior President's practice direction says that the tribunal should look at the notice of appeal in 3 steps. First, decide whether there is a right of appeal on paper. If there is, then the second step is decide whether the appeal is in time. If not, whether time should be extended. And the third step is give any directions. This is practice direction 3. The Chamber's President has likewise issued similar practice directions. But what happens next is that there are then standard directions. The appellant then is required to file a skeleton argument and evidence. The Secretary of State is then required to file a review of that evidence, and there is then a fact-finding hearing. Simply no room at all for any process akin to summary judgment. Miller and Friend used the word unscramble repeatedly in his oral submissions this morning. And that, of course, triggered certain questions from the bench. But if anyone in this room is seeking to unscramble things, it is with respect to the Secretary of State. It's just not possible to accept the proposition that Miller and Friend advances, the proposition that there should be a summary judgment akin process, without unscrambling the rules, the practice direction, the practice statement, the primary legislation. But this proposition is inherently, with respect, unattractive for another reason. What is the point? What is the point of the tribunal hearing evidence from the witnesses and then deciding whether or not time should be extended or whether the appeal was in time? In this case, if the matter goes to the hearing, you have the grounds of appeal that were filed to the First-tier Tribunal. What will really happen is that the appellant will give evidence, his uncle will give evidence, They, I expect, would say that, well, the appellant was dependent on the uncle when he was in Bangladesh. The uncle was supporting him financially. If a judge believes their evidence, the judge will allow the appeal. It's impossible, with respect, impossible in a case of this sort for any properly directed tribunal to hold that the appeal is hopeless or bound to fail at this stage without hearing evidence. Merits of the case with respect are simply irrelevant when it comes to the question of whether there is a valid appeal before the first-tier tribunal. Merits are also irrelevant if we reach the second question, namely that the appeal is out of time and time should be extended. In my skeleton argument, I've referred to some well-known authorities, Mitchell, Denton, Heisage. We decided not to put those authorities in the bundle because what they say is fairly well settled. Miller and Friend would not dispute, my lords, that one of the things that those authorities said very clearly, that merits of a case have nothing or little to do with whether time should be extended. In answer to a question, Miller and Friend, I think, made it absolutely clear that he's not asking the court to decline to. He's not making a point as to Section 31(2)(a) of the Senior Courts Act. He's not saying that it's highly likely that the outcome would not be substantially different. He made that argument.
That's just on judicial review. Well, I suppose this is a and he's not relying on that for the tribunal decision, i.e., the upper tribunal judicial review decision. No.
Yes, he's not making that point before this court. He made that point at the upper tribunal. The upper tribunal rejected it for good reasons. If you wish to see why it was rejected, may I ask you to look at paragraph 61, page 77. Paragraph 60 makes the point that, well, it's just not possible to prejudge the outcome of the appeal that hasn't really started, and then deals with Section 31(2)(a) at paragraph 61.
Sorry, you gave us reference 77.
Page 77 of the bundle, yes. So you'll see a heading. Sorry, this is page 77 of the appeal bundle.
Yeah, no, that's where I am. Sorry, catching up. Yep, I'm with you.
Yes, you'll see a heading relief.
Yes.
Look at the end of paragraph 60. The judge made the point correctly that it's just not possible to prejudge the outcome of the appeal that hasn't really started, and then deals with the highly likely point at paragraph 61. That's not being challenged.
Yeah.
So so just to summarize the position, Miller and Friend is not saying that there is substantial compliance. What he says is that it is arguable that the appeal is doomed to fail, and that, for the reasons I've given, is a bad point, and that, with respect, in my submission, is the end of the appeal. Miller and Friend then took you to 6 authorities from the tribunals. I will not take you to those authorities, but what those authorities say is that the time to bring an appeal does not start to run until the service of the notice in accordance with the notice's regulations. That is the fundamental basic point that is made in all 6 authorities. You look at the upper tribunal's decision, you'll get the relevant paragraph number, but that is the fundamental point that those authorities made. Now, those authorities are from the Asylum and Immigration Tribunal, the upper tribunal. They're of course not binding on this court, but I have made a submission in my skeleton, which I respectfully seek to make orally too, that this court in this case is dealing with an aspect of tribunal law and practice. What the upper tribunal has said is not binding for sure, but it is appropriate to exercise judicial restraint when it comes to considering a question that is an aspect of tribunal law and practice. It is probable that in understanding and applying the law in their specialist field, the tribunal will have got it right. The authorities for that proposition are Jones in the Supreme Court, paragraph 25, and Ahad Sudan, paragraph 30.
Does that principle apply not merely to the substantive merit of claims and appeals, but also to the question of procedural compliance?
Yeah, it's a fair question, Lord. In Jones, Lord Conworth referred to an aspect of tribunal law and practice. These were his words, tribunal law and practice.
We just pick that up.
Yes.
That was that when he was actually senior president himself?
When this is the Supreme
That was
Court,
at the
Jones
Supreme
in the
Court,
Supreme
yeah.
Court. If you look at Jones, it's tab 30.
Yeah. Let's just look at that.
The relevant paragraph, I think, is
What are the facts again? Because if he's talking about tribunal law and procedure, it's quite helpful to know what he was dealing with, because he might have used tribunal law and procedure in relation to that. So, what was the particular point of procedural law that they were dealing with? Oh, what is a crime of violence? Is it?
yes, it's paragraph 25.
Okay.
And then it is well established, it's a general proposition that an aspect of tribunal law and practice, judicial restraint should be exercised when the reasons that a tribunal gives for its decisions are being examined.
Sorry, that's at page.
It's page 305.
Thank you.
Just a second.
It establishes an aspect of tribunal law that restraint should be exercised when the reasons that the tribunal gives its decision are being examined.
Yeah.
So it's not restraint about a tribunal
Yeah.
law and practice. It's benevolent interpretation or reading of decisions.
Yes. Yes.
The appellate court should not assume too readily, forgive me, that the tribunal misdirected itself just because not every step in its reasoning is fully set out.
Yes.
It doesn't that really seem to go to the substantive decision making
Yes.
rather than procedural compliance?
Yes. So,
I mean, we've got to read 19.2 and like we read any other rule or statute, whether it's tribunal or not, and decide what that means.
yes, you may wish to look at Ahad Sudan just in case if that offers any assistance. So if you look at
Which tab?
yes, my apologies. It's just that when we were discussing the contents of the authorities bundle, we decided to skip Ahad Sudan as well, because what I said in my skeleton argument about it wasn't uncontroversial, but was uncontroversial. So if you look at my skeleton argument, paragraph 15.
Incidentally, sorry, just to while there's a pause, what you took us to in Jones was, I think, Lord Hope. Lord Conworth follows on.
Yes.
But anyway, it was said in the Supreme Court.
Yes, if you yes.
Tab 20.
20?
Sorry, Milan friend,
It's tab 30 for Jones.
tab 20, yeah, my apologies. My apologies. Tab 20 of the authorities bundle. It has Sudan, and the relevant paragraph is paragraph 30. So just against letter D, page 161, it is probable that in understanding and applying the law in their specialized field, the tribunal will have got it right. Now it is, but Lord Justice Lewis says, I mean, I entirely accept that it is for this court ultimately to decide what the legislation meant or was intended to. But it is legitimate in my respectful submission to point out that the Secretary of State's invitation to this court is to disrupt what the tribunals have been doing for the last 25 years. So there isn't just one authority, a series of decisions by several tribunals headed by the presidents, several presidents, deputy president, all saying the same thing, that the time to bring an appeal starts from the date on which a compliant notice is served. That has been the law and the tribunal's practice for the last 25 years. I accept that could be wrong, but in my submission, it is appropriate to proceed on the basis that it is probable that they've got it right.
This is a question of interpretation, isn't it? As my lord said already, what Rule 19.2 means, and your argument would apply also to what the Court of Appeal did in Khan, saying that Sala was wrong.
Yes. Yeah,
It
so
doesn't really help very much.
no, so the decisions are not binding, of course, in any sense, but of course, just given that my lord has referred to Sala, and of course there is one decision that was Sala, which this court said was wrongly decided. Here you have a series of 6 or 8 decisions starting from 2002 until 2018, all saying the same thing. But of course, I accept that it's open to the court to say that what the tribunals have been doing for the last 25 years was wrong.
What we see in AH Sudan seems to be the Supreme Court talking about the application of legal principles to deal as summarised in paragraph 34.
Yes, in understanding and applying the law in their specialist field. Yes, so what was said was that in understanding and applying the law, it is probable that they've got it right. I say nothing more than that.
There are dicta of Lord Carnwath elsewhere, I think, not in the cases we've looked at here. But my recollection of them is that they all go to the application of legal principle rather than
Yes.
the strict question of procedural compliance.
Yeah. So there is a recent judgment by this court where all 9 or 10 authorities were cited. But of course, those are cases where the point is about judicial restraint when reviewing the reasons given by a fact-finding tribunal. Expert tribunal. Precisely. So the only 2 authorities where there was a reference to law as opposed to facts was Jones, where there's a reference to tribunal law and practice, and AH Sudan, where there's a reference to understanding and applying the law.
Yes.
Now,
We haven't looked at the regulations, and it may be that we don't need to decide these points, and it may certainly not be for you. But if we look at page 19 and the contents of a notice, 5.1a is statement of reasons. 5.3 is the right of appeal, whether it's inside or outside the United Kingdom, the grounds. Does that mean a reference to the 2006 reg will be enough? The facilities available for advice and assistance, and then you go on the time between appeal, the address and so on. There's quite a lot of things. So to say a compliant notice might beg quite a lot of questions. It may be that we should just confine ourselves to A, because we haven't really heard any argument about that. But because they haven't given any facilities, a Citizens Advice Bureau or a legal aid practice, or because they haven't said the time limit or given a fax number and so on. When you say compliant notice, it would be helpful to know whether you mean something that completely satisfies those requirements, i.e. it will have been met, or whether some can be left out, or there might be scope for decision and so on. This case is easy in one way because it's the right of appeal, and he was told the opposite of what the position was.
Yes, so this is really A.
It is
And I'm entirely content for the court to say that, well, this case is really about A, nothing else. And there is no dispute between the parties that A was not compliant with. Miller Friend does not submit that there was substantial compliance. There is, I respectfully agree, no need for the court to look at B, C, and D in the circumstances.
4. Subject in the notice given under Regulation 4 shall be accompanied. What's that about? Oh, that's for the notice. No, what's that about? Little 4.
Yes, so you have to provide the actual form, the notice of appeal form.
So the Secretary has got to say there is a right of appeal, and he's got to give you, or she's got to give you the form to fill out.
Yes, and that certainly was the practice or the position prior to the online portal that has now been established.
Because your client wasn't given a copy of that document, was he? He can't have been.
Because there wasn't a right of appeal. So there was obviously a sort of wholesale.
So when you say we need to look at 3, I'm wondering if that's right, whether we need to look at 4 as well or not. 5.4, subject to paragraph, the notice given under Regulation 4 shall be accompanied, not included or accompanied, be accompanied by a notice of appeal. We haven't looked at these provisions,
No.
which indicates various things. So do we have to look at non-compliance from the point of view of 4 in your case as well as 3A?
Not necessarily with respect, because well, for the in order to decide this appeal, it is perhaps enough for the court to simply focus on 3A, perhaps, because there can be another case where a person was advised about the right of appeal facilities,
But not send the form and
But
not
not
give the
send-
right form.
not send the right form.
To give guidance for all cases, we'll have to have one by one and the Secretary will have to guess what you've got to do. Would you say that's not your problem?
Yes. I mean, this code in OS Russia gave a solution, a principled solution that, well, if there is non-compliance with any of these requirements, then that means that the notice is invalid. But I do not need to make that argument in this appeal. But I think if it is, if the point is troubling my lord, then perhaps it's appropriate to just to highlight that it's common ground that there was a sort of wholesale failure to comply with the requirements.
There's one other question about the authorities. I have that. You say the authorities all establish that if there's a notice which is not compliant, the time to appeal to run. In paragraph 38 at page 72, the upper tribunal summarises the authorities and additional to, and I asked Mr. Ostrowski about this, it says, for the purpose of bringing an appeal, time starts to run against a prospective appellant upon receipt of a notice of decision. Do the authorities say that? Because the regulations say when it's sent.
Yes.
Is that just a mistake?
No, it's not. It's just that there is, it's not an issue in this case, but there is an argument supported by authorities that in this context, sending is equivalent to receipt, because unless a decision is received, it is not a decision at all. So sending of a decision, if it is not received by the appellant, is not a decision at all.
Why do you say that? What's your authority for that?
Well, if Well, it's section, it's not an issue in this appeal, but it's
No, but I
section,
mean, we've got to
section
think
4.
about it, because if we're approving this statement, and Mr. Ostowski's told me that it's wrong,
Yeah.
and I crossed out receipt and put in sent, but if you're telling me actually he's right, and 9.2 means received by the appellant,
Yes.
not sent by the respondent, it'd be helpful to know that, so we don't make an error here. We don't want to repeat about
No.
that.
No, I get that. So if you,
Is the language of receive or received used actually?
section 4, yeah. So if you look at tab 1 of the authorities bundle, page 8.
Yeah.
Section 4, the power under this act is to be exercised by notice in writing given to the person affected.
Yeah, but that doesn't apply here, because it's not, this is a
This is the-
regulation, 2006 regulations, refusal of a card, and that doesn't have to, the section 4 doesn't apply to that. But you're saying that's why he uses the word receipt, not sent, so we ought to be careful in our judgment not to confuse or suggest it's the one, not the other, because I've read 19.2 and assumed it means sent, but you're saying in context, sent meant received. Because if you look at the notice regulations,
Yes.
there's lots of things in regulation 7 about when it's deemed to be sent.
So, Lord, can I respectfully
Yeah.
say this? I mean, I have of course no desire to make this case more complicated than it already is. So I'm entirely content for my lord to use the language that is used in Rule 19. That refers to sending of the decision. And if my lord say that in the judgment that, well, the time starts to run from the date on which a compliant notice is sent, I don't have a problem with that or not.
And then I can leave,
Sorry.
I can leave it to other people
Yes.
to work out that I was only talking about the EEA decisions, not the appealable decisions, and we can have another court case in 2 years' time. But what did he mean this time? Yeah.
Yes, but nothing objectionable in using the language that is used in the rules.
There's a contrast in Rule 19, page 42 of the bundle, between 19.2, which we have to deal with, which uses the word sent
Yeah.
for a person in the UK, and then 19.3, person outside the UK,
Yeah.
little b, in any other case, not later than 28 days after they receive the
Yeah.
notice. So the legislature has clearly distinguished between the two.
Absolutely. I mean, there can be another hearing, half a day on that. There are authorities on the subject, but I'm entirely content for the court to proceed on the basis that Rule 19 refers to sending of the notice. I don't have a problem with that.
Because the 2003 regulations, Regulation 7, deals with the situation where you don't know where the person is, which is often the case. And they say it's enough there if it's sent to him at his last known address, or even if you don't know what that is, you can just
On the file.
enter a record.
Yeah, on the
So
file.
that's why I can't see how receipt, that sent means receipt in all cases. Because in lots of cases,
I agree.
the regs and the rules make different provision. That's why I'm puzzled about his statement in 38.2. And since you're going through the decisions, I thought I better just check whether it's now accepted that sent means receipt in all cases, to which the answer is no, and we don't need to worry about it as long as we make it clear what we're dealing with.
Yes.
I mean, the operative provision here is 19.2.
Yes. So that refers to sending. I'm content for the court to
That's what,
say that.
that's what it says.
That's the sending. Now I then, Lords, turn to the actual ground on which the Secretary of State has permission to appeal. The ground was effectively abandoned towards the end of the submissions that Miller and Trent made. If you look at the ground on which Miller and Trent has permission, that ground is that the upper tribunal erred in holding that Marapali does not address that question. And the argument is that, well, Marapali is binding. Miller and Trent, I'm sure the Lords will recall, took you to Marapali, said at the end that he accepts that Marapali does not address the issue of when time to bring an appeal starts to run. That, with respect, is the answer to the ground of appeal. Marapalli was a different case. It wasn't dealing with that issue. Nowhere in that judgment, my Lord Justice Lewis said that the time to bring an appeal starts to run from the date on which the decision is sent. I will not take you to Marapalli, but my Lord Justice Lewis knows that that was a case where the appellant was not seeking to challenge the underlying decision, accepted that that decision was fine, but was seeking to submit that, well, his
No,
leave-
that's not correct. What he was saying was that the decision didn't exist.
Yes,
And
at
the
all.
application was undetermined.
Yes,
That's what he was saying. It's
Yes.
quite the reverse of what you were saying.
yes,
He was saying because there was no notice, no valid notice,
yes,
therefore there was no underlying decision, and therefore the application was still in
Yes.
place, and therefore leave to remain continued.
yes. But as my Lord noted in the judgment, that there was no challenge to the underlying decision. He accepted
Yeah.
that the requirements of the rules were not met. So a legitimate question then arises, the question that my Lord asked in that judgment, well, what's the point? There is no conceivable disadvantage.
Challenge to a later decision by reference to what was said to be a flaw in an earlier decision,
Yes.
which rendered it non-determined. But it doesn't address this issue.
So Marapalli is certainly not binding. The upper tribunal was absolutely right in saying that, well, that dealt with a different point. If you wish to see the upper tribunal's analysis, it's paragraph 42 to 59. And I respectfully adopt that analysis of Marapalli and Ahmed. This isn't a historical injustice case. I'm not suggesting that the decision to refuse leave was a nullity. So there's nothing in Marapalli that, with respect, undermines the submission that I make. Melanchthon then makes a submission. He made the submission in his skeleton, hasn't really developed it orally. He said, well, if this court is to approve the upper tribunal's decision, the Secretary of State will be in some real difficulty. He says that, well, that essentially means that a person who has made an in-time application for leave to remain or a citizen's right application that was refused with a defective notice, their leave will automatically extend for an indefinite period. This is not what the upper tribunal said. That is not the effect of the upper tribunal's judgment. I mean, I make no such argument. I've accepted at the outset. I accepted below that the Secretary of State validly refused the appellant's application. So that isn't an issue. But if there is a problem, then the remedy is in the Secretary of State's hands. She should comply with the law. And if the problem arises because of her non-compliance with the law, then she is the one responsible for it.
On that, on page 98, there's a chronology. Can I just double check that I've got this right? That the applicant's leave to remain as a Tier 4 migrant, that expired on the 25th of May 2016. So he didn't have leave to remain after that time. And then he made another application in October, about 5 months later. And then there was all the proceedings with that. And then it says 14th of November 2020, he claimed asylum. Do we know what's happened to that application?
Sorry, my solicitor has disappeared. The application is pending. Okay. So Melanchthon says that that application is still pending.
All right, so that hasn't been determined.
To be clear, that's an application precisely for what?
Asylum.
But it's nearly 4 years ago.
Yes, I'm afraid I don't know any more than what I've said. It is
Okay.
pending.
But his last leave to appeal expired on the 25th of May 2016. Is that right, Mr. Malley?
Yes, this chronology is uncontroversial.
Yeah, okay.
Given that, my lord, you have asked a question. when it comes to the entitlement under the EEA regulations, the fact that a person is an overstayer is of no consequence whatsoever.
No.
So all the appellant has to demonstrate is that he was and is dependent on
Say
his
two,
uncle
yes.
or the member of the same household. Whether or not he claimed asylum, whether or not he was an overstayer is not relevant to that inquiry.
It may be relevant to, in all the circumstances, whether the discretion should be exercised to grant a residence card, but we don't need to worry about that.
No. Yeah, so for these reasons, I submit that the judge was right to quash the first-tier tribunal's decision and to declare that the appeal was not out of time. Now, what is also, with respect, remarkable is that Miller & Friend is not seeking to defend the first-tier tribunal's decision. He accepts, he will correct me if I'm wrong, he accepts that the first-tier tribunal's decision was unlawful. And therefore, the decision to quash it, that decision must stand. What he is inviting the court to do is to effectively quash the first-tier tribunal's decision again that has been quashed and remit the matter to the first-tier tribunal. Even if the Lords accept everything that Miller & Friend has said, in my submission, the appeal, insofar as it is appeal against the quashing order, must still fail because Miller & Friend accepts that the decision of the first-tier tribunal is simply unsustainable.
If we simply dismiss the appeal, if that were the decision of the court, the consequence of that, without more, would be that the right to appeal is active from the moment of, well, it continues to be.
But he's appealing against the declaration too. He declared, he granted
Yes.
a declaration that it was in time. So
Yeah.
he can argue that that was wrong. And although it was quashed, it was right to quash it because the wrong test was applied by the first-tier tribunal, is
So-
what I think he's saying.
Yes. So that really is the live issue. So there's no question in my respectful submission that the decision was correctly quashed. The only issue is about the declaration, whether the appeal was not out of time.
Yes. What he says, I think, is correct to quash it, wrong to declare that it was in time. What he should have done is quashed it and returned it to be decided in accordance with the principles he's outlined.
And I respectfully invite you to uphold the quashing order and the declaration. By the respondent's notice, I have made an additional point, which is I'm not sure if I need to develop that point in my oral submissions, given that the defendant is not seeking to defend the first-tier tribunal's decision. And I argued that, well, in any event, the tribunal erred in law in declining to extend time. The three-stage test was not properly applied. The fact that there was non-compliance with the notices regulations was obviously a clearly relevant factor which wasn't taken into account. So even if Miller & Friend is right, the tribunal should not have rejected the appeal as out of time. But if you agree,
Say the declaration, the appeal against the declaration is allowed. The position we've got at the moment is that the decision was quashed, and the decision was the decision that there was a valid appeal, that it was out of time, and that discretion wouldn't be exercised. If we allow the appeal, it'll only be against the declaration, so we don't know that it's in time. But the decision that it was in time and the refusal to extend time Has that in any event been quashed?
Yes. And the matter will go back to the tribunal. The first-tier tribunal will decide whether to extend time.
But if he's wrong, we allowed the appeal and said it was out of time, just trying to think through the permutations. If we say it's out of time and the tribunal decision was wrong for that reason, then you would have an argument about this. But you say that's not what Mr. Ostrowski is asking for now. Because he's not asking us to say that it's out of time. He's asking us to say the first-tier tribunal should apply a different test in deciding whether or not it's out of time.
Yes. So this.
Agree with that?
Yes.
Yeah. Okay.
So this, in other words, if you agree with Miller and Friend, this will go back to the first-tier tribunal.
Anyway.
Yes.
And they'd have to decide everything again, the out of time and the extension.
Absolutely.
Yeah.
But if you agree with my submissions, then that effectively means that there will be a full hearing in the first-tier tribunal. The point about out of time being determined, and the tribunal will simply issue directions for the full substantive hearing.
Right.
So unless I can assist you any further, these are my submissions.
Thank you very much, Mr. Malik. Thank you very much, Mr. Malik. Yes, Mr. Ostrowski, you're.
My lord, I don't intend to trouble the court other than to make two, I think, short points, more by way of clarification, I hope. The first is I accept that the authorities that I took at the court to do not directly address the question which is before this court. What I say the authorities do consider is giving an indication of what Parliament intended to result from the failure in the notice to articulate that Mr. Chowdhury had a right of appeal. And I say, for the reasons I set out in my submissions this morning, that these cases do conclude that Parliament's intention is that invalidity does not necessarily result when the notice is defective in circumstances when either there has been substantial compliance or non-compliance has not had a material adverse impact on the recipient, or when remedying the effect of non-compliance would cause adverse procedural or other consequences. My learned friend suggested that I abandoned the grounds of appeal relating to Maripali. I disagree. The grounds of appeal are phrased as follows: that the upper tribunal erred in holding that the authority of Maripali does not address the question of when the time for appealing against the decision starts to run in circumstances when a notice which was defective is served. I do not abandon my submission that Maripali does address that question.
Well, no, it doesn't address the question, but you say the question it does address might help you answer that question.
Yes, I suppose put that way, yes.
It does address a question germane to the question at issue in the appeal.
Yes.
Is that it?
Yes, it addresses a question which is germane to the issue. I I certainly don't concede that Maripali is not relevant.
And the question being when a notice which is non-compliant in certain respects may not result in invalidity.
Yes, or put another, when a notice which is non-compliant in certain respects, when time starts to run.
But it didn't address that. We've just agreed it only addresses when it was defective, and you're making the leap. But if it's not defective, therefore time does not run.
Yes, I say it's related to that letter question. Yes, indeed. That's the first point I wish to say. The second is, my learned friend on behalf of Mr. Chowdhury says that it would be impossible for the first-tier tribunal to determine that the appellant would be doomed to fail, and hence there's no conceivable way that the tribunal could conclude that the appeal was doomed to fail, and hence that it would be impossible for the first-tier tribunal to conclude that there'd be no material adverse impact on the recipient of the notice. The short point in response to that is that Rule 20 permits the tribunal to decide any issue under this rule as to whether a notice of appeal was given in time, and it can do so with or without a hearing.
What about evidence?
That's not specified, but even on the approach most beneficial to my learned friend, i.e. no evidence, while perhaps unlikely, it is not inconceivable that a tribunal could find that an appeal was doomed to fail, if, for instance, admissions are made.
But from what Mr. Malik told us, all you have at this stage is the notice of appeal that sets out the grounds. That goes in, and stage one was, is there a notice right of appeal? Answer yes. Look at Khan, Court of Appeal. Next question, is it within time? And you're doing that, I thought Mr. Malik had persuaded us, and he does it all the time, by just looking at the notice of appeal.
So yes, there's an online portal that just consists of the grounds of appeal, but it doesn't follow that what's set out in Rule 20, Sub-Rule 4, is limited to just the documentation that is in the online portal.
No, you can put in written evidence, 20 Sub-Rule 3. And if the tribunal says that it may be out of time, the person may provide the tribunal with written evidence. You can't call the uncle or Mr. Chowdhury, can you?
No, it's going to be on the written material. So there'll be a hearing, written material from the portal.
So you'll have the grounds, you'll have a statement saying what my uncle and I say is true, and the secretary saying, no, it's not true. And don't you have to ask them? Don't you have to look them in the eye and say, come on, Mr. Chowdhury, is this really true?
As I say, I accept it is unlikely, but admissions may be made in that written documentation. There may be inherent inconsistencies with what is said.
That's quite normal in the tribunal, for there to be factual disputes, which are resolved ultimately by the tribunal seeing the witness and seeing the witness cross-examined.
There could be factual disputes that are so central they would be impossible to resolve.
That is the normal nature of the process before the tribunal, isn't it?
Yes, that is the normal approach, but in my submission, it is not inconceivable that things could be said that so undermine the assertion of dependency on the applicant's uncle that it would be impossible to get around that. that was the second and last point in reply that I wished to say, unless I can assist your lordship.
Yeah, nothing else.
Thank you very much, Mr. Ostrowski. Thank you both very much, and all those who've helped you in the preparation of the very clear submissions you've made to us in the course of the day. We shall reserve judgment, wanting to reflect on the submissions made to us, both in writing and orally. In due course, when judgment is handed down, a draft of the judgment to be handed down will be circulated in the normal way. That will be available on the strictly embargoed basis that will be familiar to the parties, for the purposes of typographical and other minor factual errors to be corrected. A draft order should be considered and presented to the court, and any submissions made on consequential matters at that stage, please. Thank you.